Hi everyone, welcome to Business Law to 10. Our next subject is about the third party rights, discharge, breach, and remedies. Our learning objective of this topic would like to present or to understanding what is the difference between an assignment and delegation. What factors indicate a third party is an intended beneficiary? The next one that we are looking forward to learn about this course, specifically this subject, is to understand how is the difference between compensatory damages and consequential damages. What are the nominal damages and when do courts award them? Under what circumstances will equitable remedies be available? What is the rationale underlying the doctrine of election of remedies? These are the things that we are learning as an objective. Our next topic is about the assignment. If you look at the connection between there's a bilateral relation and there's a rights relation connection that is connect right between offerer and offeree, and that's required third assignment. The assignee has rights, its difference performance after assignment. So there's a transfer of contractual right to a third party or assignee, and the assignee has the right to demand performance from the other original party or obligor to the contract. And you cannot assign rights for personal services or when obligor's performance change. This is you can see where the case of Forest Commodity Corporation versus Lone Star Industry back in 2002. Our next subject is about delegation. In the delegation, same, there's a bilateral connection between the offerer and offeree, and there's also duties between the offeree from offerer to the offeree, where the third party delegated and the offerer delegates duty to third party and then duties to the offeree. So there's a transfer of duties to third parties or delegatee by delegator. The legatee owes duty to original party in a contract, and then the legator is still liable for performance of duty. The next one we are going to discuss about contract discharge. Discharge is the full performance of all duties. The condition to performance. Condition is a possible future event that might or might not happen. Triggers or terminate performance. The condition of precedence prior to performance. Condition of subsequent or follows initial performance, and concurrence or occurs simultaneously. And there's also contract. Next one is discharge, contract discharge. Discharge is the full performance of all duties, where the condition of to performance will include condition is a possible future event that might or might not happen. This triggers or terminates performance, condition precedence prior to performance, condition subsequent follows initial performance, and concurrent or occur simultaneously. And discharge by performance is the complete versus substantial performance, where the complete performance is actually perfect performance under the contract. And substantial performance is the technically a minor's breach, but as long as in good faith, the non-breaching party remains liable to pay. The next one is about the satisfaction contract. This is the situation where performance is conditioned on reasonable satisfaction. Contract discharge can be a material breach when performance is not substantial. The innocent party is excused from performance and has the right to sue for damages. So a minor breach might be cured. This has happened during the case Kim versus Park back in 2004. The anticipatory repudiation might happen where the one party gives notice of refusal to perform. So the innocent party treat ER or anticipatory repudiation as a material breach. So discharge by agreement is does happen when discharge by mutual resignation. Um, Parties must make another agreement in this particular situation. Discharge by novation is happen when you contract with substitution of third party for one of the original parties. And accord and satisfaction, you can do settlement to discharge original contract. Discharge by operation of law. Though these include contract alteration, statute of limitations, bankruptcy, and impossibility of performance or objective. What's happened with the impossibility of performance includes parties' incapacitation, subject matter is destroyed, performance becomes illegal, or commercially impracticable. What's happened with the damage? Damage might involve compensatory damages, compensate injured party or plaintiffs, and the plaintiff must prove actual damages caused by breach, and the amount generally difference between defendant's promise, performance, and actual. Or depends, you can also do sales of goods, difference between the contract price and the market. Damage can do or can happens like consequential or special damages. There's foreseeable damages that result from breach of contract caused by other than breach of contract. The punitive or exemplary damages, such as deter wrongdoer or set example. There's also nominal damage. The next one is about